Welcome to Expert Views on ADR Ever, a podcast about simplifying the traditional African method of settling disputes or the appropriate dispute resolution ADR in a bid to attract more users to settle their disputes or conflicts with mediation, bonds, collaborative law, arbitration, restorative justice, early dispute resolution, negotiation, conciliation, and of course, early neutral evaluation. My name is DrChinweEgbunike, the host of Expert Views on ADR Ever video podcast show, and I'm delighted to welcome Dr. Dawn De Coteau to the Ever show. She is a legal practitioner that practices law in England and Wales and several Caribbean jurisdictions, a fellow of the Chartered Institute of Arbitrators, CIArB, with experience in arbitration and mediation, having been appointed arbitrator and mediator in various matters pertaining to maritime, estates, commercial and corporate, contentious, probates, and of course, family disputes. She wears many hats, so I've left the link to her profile. Welcome to the show, Dr. Dawn.
Thank you very much. Welcome, welcome, welcome. Thank you very much for having me.
Okay, so without further ado, the first question is, what is the role of ADR in dispute resolution or conflict resolution, and how far has it enhanced access to justice in the Commonwealth Caribbean jurisdictions, specifically in Grenada and St. Kitts and Nevis? Thank you.
Thank you. Yeah, great question. Great question. So obviously, alternative dispute resolution is very much that, is an alternative to parties resolving their dispute that they may have across various legal streams. So critically, the role of ADR, one of the key roles, is really to assist the courts to, one, reduce its backlogs, because everybody, the traditional route is really to go to court, issue proceedings, but alternative dispute resolution is, that first point where parties can try to resolve matters without having to, either before issuing proceedings or indeed after issuing proceedings. But the key is really, there's multiple kind of benefits. Obviously, the courts to reduce backlogs, but also benefits for the parties to try and resolve their matters at an earlier opportunity. And we'll discuss some of the benefits and rationale for that as we move forward, no doubt.
Okay, thank you so very much. So what is your take? Has it enhanced access to justice in the CC region?
Well, yes, I would say yes, especially for those who in the region, in the Caribbean, in Grenada and St. Kitts specifically, those who may not have the financial means to instruct lawyers to deal with their matters, you see, and, so therefore, being able to access an alternative dispute resolution and predominantly mediation, because that is predominantly the ADR mechanism that is used, even though we've just introduced judicial conference settlements. But generally speaking, it really does enable those who may not have the means, the financial means to access a lawyer, to actually engage in mediation, which of course is swifter and cheaper than it is then to, commence litigation, which can be quite costly, as we are aware.
Yeah. Oh, thank you so very much. So what I hear you say is that it's cheaper and more, it's not time consuming when compared to litigation.
Well, yes. I mean, if you think in the region, a litigation matter here, because of the backlog, from the point of issuing to trial, can take anything up to 2 to 3 years. Once you issue a claim under the various CPR rules, by way of an example, the court-appointed mediation in Grenada and St. Kitts, it's governed by the CPR rules. So once you go once you file your matter, and you go for your first hearing, the master is likely to channel parties to try and resolve matter to mediation, and matters are then stayed whilst parties try to resolve that. And that could take 3 to 6 months as opposed to 2 to 3 years, and sometimes even longer to have a matter resolved if it goes all the way to trial, in the jurisdiction. So most definitely it is a swifter process.
Oh, thank you so very much for that. So, is there any history associated with ADR in the Caribbean region, specifically in Grenada and St. Kitts?
Well, the history in regards to where we are now, the first piece of court-appointed mediation was incorporated in the CPR, firstly in St. Lucia, I believe, in 2002. And so, but then that was rolled out across all of the OECS members. So as a result, in the CPR rules, you will see that court-appointed mediation is a requirement. And under, I believe, the recent or the revised CPR rules 2023, we also have the judicial settlement conferences where you have the opportunity for a judge to come in and basically, look at the matter, try and, give an opinion on the merits to the parties, obviously with consent. But the point is, we can see that prior to the judicial settlement conferences, it was mainly court-appointed mediation. But now we see an extra mechanism in regards to the conference settlements, which have been quite useful, and albeit fairly new, but quite useful, definitely.
Thank you so very much. So I was asking about the current laws and regulations that pertains ADR practices in Grenada and in St. Louis, but I think you've sort of touched on it. But I wanted you to clarify if there are any new laws or maybe amended laws in arbitration and mediation.
Right, yes. So arbitration is the one where in Grenada and St. Kitts specifically, our arbitration laws are quite archaic, dare I say, and are in need of revision. We are not in the place we are not in the same place as countries such as Trinidad and Guyana, who have recently, as you are aware, revised their arbitration laws. Because as I say, I am a champion for arbitration, being a fellow of the Chartered Institute of Arbitrators. And one of the things that we see in the Caribbean is that, let's take Grenada, let's take St. Kitts, let's take Nevis. These are islands, countries that are, open for investment, for the economic benefits. We're always looking at, bringing in investment, big investment at the same time. But as I say, in doing that, it would be extremely premature not to factor in, being arbitrational or dare I say, ADR fit for purpose. And it's interesting that, in Grenada, in St. Kitts, and dare I say in Nevis, where we have got a lot going on in regards to calling out for investors and individuals and private sector investing, but yet our arbitration laws fall by the wayside, in that they are very much in need of revision. And it's interesting because only just yesterday I was just putting
Sorry, I didn't get that. Your mood? Okay, I can hear you now. Sorry. Oh no, this is. Hi, Dr. Dawn, can you hear me?
Can you hear me?
Yes, I can, but I didn't hear the whole lot of what you said previously.
Right. So should I just repeat that? Should I
Oh,
just
yes,
repeat what
please.
I'm saying?
Thank
So I
you.
was just saying, in with picking up on the issue and where we are with arbitration.
Hmm.
Only recently, I've just put a call out for colleagues in Grenada with a view to setting up a Chartered Institute of Arbitration chapter here in Grenada, with a
Okay.
view to starting those discussions around, pushing the agenda because it is so important. And
Hmm.
again, potential missed opportunity if we don't look at this and start drilling down. And then, we maybe can make the call for, keep knocking on the door of the AG and government to, get the buy-in to change their arbitrational and legislation.
Hmm. Oh, thank you so very much for the insightful um, updates on
Where we
the
are.
where you are at the moment, especially with the arbitration center that would be coming, very soon. Fingers crossed, and I wish you
Yes,
the very
chapter is
best.
very important. Yes,
Wish you the
absolutely.
very best. Okay, so compared to litigation, is there any measurable difference between the cost and time frame for settling via ADR when compared to litigation? Because I know your research, your PhD research also centers around um, comparison between litigation and ADR or time frame or something like that, or effectiveness of ADR.
Well, no. My PhD,
Yeah.
my doctoral research focused on a different area, corruption in Caribbean politics. But
Okay.
yes. However, I think it's my other hat on is the ADR hat, and through the Chartered Institute of Arbitration, I'm the
Yeah.
one that's looking at the comparison. I'm looking at comparisons
Yeah.
in the region of what's happening in regards to ADR
Yeah.
and where we are. But I think in regards to your specific question, I think already, as I've mentioned, obviously we have our civil procedure rules that basically requires parties to engage in court-appointed mediation. And that has been a success and been a success for a number of years for a number of reasons, because obviously it means that parties do have to try to enter into mediation with a view to trying to settle. And if they don't, then, the courts can, take a view on that, depending on the rationale behind it. But I think at the end of the day, we are mediation is still fairly new in the region. We must remember that. But
Mm.
as a result, even though I think mediation has been the ADR tool that has been pushed, but notwithstanding, I think in regards to other forms of ADR, arbitration, negotiation, etc., these are areas that I think that we do need to explore further, because there are other angles and other tools that are available to assist parties to reach conclusions of their matters at earlier opportunities.
Thank you so very much. So, but Dr. Dan, I was wondering if there are any statistical data, empirical, um, to buttress
There would
that
be
point. Yeah.
statistical data, and that would be available through at the respective registries. And
Okay.
that is something that I would imagine is quite easily accessible. It's just
Hmm.
that I don't have that data to hand to
Hmm.
share with you at this juncture. But if that's something that you wish to obtain, that's
Yeah.
something I could assist you with. But what I can say, most matters, albeit I think non-contentious probate, family matters, insolvencies, would be subject to court-appointed mediation.
Okay. Thank you so very much. So when it comes to employers or workers in Grenada and St. Kitts, are they aware of ADR options regarding disputes? Can you hear me?
Yes, I'm hearing you. I'm
Oh,
hearing you.
okay. Okay.
Yeah, I'm hearing you very clear. So in regards to employment, so
Yeah.
obviously we have our labor laws, yes, and so there is always scope for parties to try and resolve matters in any event through the procedures, and there is that opportunity for dispute resolution. But in the event that parties are not able, an employer-employee are not able to reach resolution, then just like anything, they are able to issue proceedings before the courts,
Yeah.
before the High Court. And again, in any event, because it's an employment matter, that would be subject to parties trying to resolve matters via a court-appointed mediator who would be neutral, who would be impartial. So again, those mechanisms are there. I think what I would say is that at the point I was making on the previous question
Yeah.
is ADR in the region is fairly new, and
Mm.
when you think about in the grand scheme of things. And so we do have parties, unfortunately, who still want their day before the court and before the judge. Even though that has improved, there is that kind of psychological notion that if I want to go to court, I don't care, I'm going to court because I want my day. But we still have a duty to edify and convince parties that
Yeah.
you can get an outcome that could
Mm.
be far more favorable, as through mediation
Yeah.
and alternative dispute resolution. So by way of an example, through mediation, you can ask for an apology. A
Yeah.
grieved party can get emotional and speak
Yeah.
about how they felt. You can ask for, compensation sometimes that would fall outside of a remit of damages, should your matter proceed, through the traditional court route, having issued a claim. And so I do think that, parties coming, before a table, and being able to look each other in and out, eye to eye, especially in employment matters,
Yeah.
and thrash out those issues. And I have been party to mediation, dare I say, where, parties have said, no, we're not going to mediation, which it's going to be, it's not going to be cost effective, it's going to waste of time. And yet when they sit around the table and you're able to then massage and canvas between the parties, you
Mm.
are able to reach a resolution. And it's
Mm.
that, for me, is very rewarding and very, very fulfilling, to see parties being able to resolve matters at mediation, especially where they were reluctant to engage in the first instance.
Mm. Thank you so very much. You said something about ADR not being quite it's still new in the region. And I was thinking about what can we do to, sensitize the public about this mode of settling disputes? Because I found out here in Trinidad that most institutions, they do not have like ombuds in place or a mediator to settle
Yes,
workplace disputes. And of
yes.
course, it escalates when there is no settlement. And I'm thinking, what can be done for such institutions and organizations here in the Caribbean, using the Trinidad as a case study now, to get the organization leaders, HR, to put that in place, you know.
Yeah,
Is that the
that's
same
a
thing
really
in
interesting, because as in England and Wales, by way of an example, you will have,
yeah,
most institutions would have a form of workplace mediator,
yeah,
who then is really a early point of contact when a dispute
yeah,
arises, irrespective of the dispute. And I do think we are some way away from that. And I'm not saying it's not in place.
yeah.
And I'm sure it probably is in places in some of the organizations, but the thing is, it's not mainstreamed. And I think what we have to recognize is that with alternative dispute resolution in the workplace, for, if nothing else, for continuity, for functionality, the earlier a dispute is resolved, yes, the better for all parties and all stakeholder, employer, employee, and it could be that irrespective of who the issues, that could be an employee dispute. But this is really important, and I do think we need to have more educational discussions and debate with human resources, with our respective colleagues holding the various hats in regards to employment disputes, because here presents an opportunity that doesn't appear to be widely utilized in the region. So I think there is definitely scope for that. But the discussion has to start somewhere, and it has to start, at least with some of our HR practitioners, our the attorney generals, by way of an example, because again, resolving these matters at the earliest opportunity can only be beneficial for all, as opposed to a minority.
Thank you so very much for that. So what is the future of international legal research in Grenada and St. Kitts, particularly in ADR?
Well, for me personally, it's definitely about, taking it further and looking at how arbitration can be a benefit to the region, Grenada, St. Kitts, and the region as a whole, and what are the disadvantages if we don't all jump on that baton and look at the benefits as we look to, mobilize our globalization in regards to investment, bringing in partners, etc., etc. My view is that you cannot, as I said at the beginning, leave arbitration aside of that. It needs to be central to the investment opportunities and the discussions that we have. And indeed, I do know that investors are asking those questions, because at the moment, if there is a dispute, which we see is going to be incorporated into contracts, but if there are disputes, the seats are usually London, most of the time, dare I say, it's London, Dubai, Singapore. We have the BVI Centre that I know is galvanizing, but at the end of the day, we have to make ourselves fit for purpose in that regard, because it can only be an added benefit, added benefit. If we're doing business in the region, then my view is that if a dispute arises, then it should be addressed, and we should have the tools to address it in the region in the event that there is a dispute. We should not have to go to, New York. We should not have to go to Singapore. We should not have to go to London. Yeah, and we've seen that, and that is an issue for me. That is a concern. And then indeed, our arbitrators, we need more qualified arbitrators coming from the region that can then sit as arbitrators, it being independent or as a panel from within the region, as opposed to coming from outside the region, So these are these nuances, but in order to address those, we have to get fit for purpose and accept the reality that unless we do this, then we're always going to be, at a disadvantage.
Thank you so very much, Dr. Dan. And of course, that with so many institutions, ADR is still not compulsory. It's not only here in the Caribbean region, but in Africa and in most developed countries. Would I say all the developed countries? I've not seen an institution that had made ADR compulsory. So I think we have a long way to go on that. But
we have a long way to go. And as I was saying, even if we look at ADR, if we look at the Chartered Institute of Arbitration, which is an international organization, as we know, but if you look at the Caribbean region, even though there are chapters, there are so many of the countries that don't have, chartered institution Chartered Institute chapters, and that has to be a starting point. And I know we're, as a committee member on the branch and the Caribbean branch, we're starting to have discussions about how is it that because of that our small numbers that we're not able to meet the quota. So we're looking at maybe collaborating, maybe Grenada with St. Vincent in regards to setting up a chapter, or indeed a wider Caribbean chapter. And I know our chair, Justice Gaffar, is in discussions with CIArb in London on that. So very, very interesting times ahead.
Oh, yeah. Thank you so very much. So final questions. The final question is most lawyers, I had a research conducted in 2021, 22. Can you hear me? Hello, can you hear me?
Hello, I'm still here. I think it may be your Wi-Fi at your end.
Yeah, I think I noticed it, but I'm trying to see if the other one recorded. But let me just quickly okay, so okay.
That's technology. When it works, it works.
Oh, it doesn't work. Okay, let me just quickly record this. So I will make it a second.
You can make some edits.
Yeah, I'll edit. Okay, so just a question about the most lawyers, like when I had this research, I think for my PhD and subsequently for my postdoc, about most lawyers not yet accepting ADR. Sort of they feel that it's a drop in their revenue. So that was the research was in Nigeria and also in the UK. So how about in the Caribbean? What are your take? What is your take? Lawyers, barristers, have they accepted ADR? Did they sort of encourage their clients to resolve their ADR first?
Well, I think what's really pushed professional colleagues to accept ADR is the fact that we do have court-appointed mediation. Yeah, and I think that has been the shift. Now, I do think there is some nuance around some lawyers thinking that, well, mediation basically shortcuts and shortchanges us in regards to if matters are resolved at mediation, it means that, they are not able to bill or charge their fees in regard if it were a matter was to be taken, all the way through the civil litigation and case management all the way to trial. And so I do think there is some that have taken issue with that. But you see, my thing is at the end of the day, the courts in the jurisdiction are basically clogged. In Grenada, it has got better because we have had some initiatives to really get through the backlog over the years. But that's not to say, 3 years for a civil litigation matter to come to finality really is a long time. Yes, so you've got to look at the benefits and you've got to look at what is right for the client in able to resolve their matter at the swiftest opportunity. And therefore I say that's also in the interest of justice and in the interest of fairness to parties at the end of the day. So I think there is a balancing act. I think what is a level of comfort for me as a avid supporter of ADR is that parties are subjected to, in the majority of cases, to court-appointed mediation. And as I said, or even judicial settlement conferences at the moment. But so therefore, you have to sit round a table. I do think that in some of the mediations that I've been party to in the region, I do wonder whether or not sometimes, as instructed lawyers, are we the best to actually be party to mediations with our clients at the time. Sometimes I felt that, I wouldn't say a hindrance, but with that objectivity is not always there as it is with an independent, neutral mediator just canvassing between the parties outside of one's legal representatives being present. And we see that also, I know in the UK, a lot of the mediations are conducted without parties, legal representatives being present.
Thank you so very much. Of course, this is so new perspectives you shared with us. I've done research around the region, Trinidad, and Guyana, but not so much on Grenada and St. Kitts. So I'm really so grateful for you coming on the show and sharing your insights and perspectives and new perspective, which I don't know about. And of course, I know that some of my audience wouldn't know about ADR in Grenada and St. Kitts. So thank you so very much. This is a masterclass, and I believe that potential users and stakeholders, HR, institutional leaders would embrace all you have stated herein, the benefits and of having ADR sector in institutions, organizations, and having ADR center in the region, particularly the Chartered Institute of Arbitrators. And, that would do us a whole lot of good and would impact on the resolution of disputes in the region as well. And of course, potential users would embrace all you have stated and opt for it whenever the need arises. Absolutely. Thank you so very much for coming on the show. I'm super, super grateful.
Thank you very much for having me, Doctor. It's been an absolute pleasure to contribute. As you know, I'm a champion of ADR. So hopefully, even if there's someone, even if we take one thing away or those that watch this take one thing from it and are able to implement, then it would be beneficial. I'm happy to engage with you further at any opportunity.
Okay, thank you so very much, Dr. Dawn. Yes, take care. Bye.